Welcome to We Learn Virtual Learning Network. This is session number 25, Legal Issues Involved in Marriage. Topics which we are going to cover in this session are Introduction, Christian Marriage Law, Muslim Marriage and Divorce Act, Special Marriage Act 1954 and the Hindu Marriage Act 1955. So moving towards the first topic, that is the introduction of the Marriage Acts. Marriage is treated as a sacred by our society from ancient time. Strict rules were laid down about female morality, kinds of marriage, marriage ceremonies, monogamy as a rule, marital duties, roles and duties of son, etc. by the Hindu society. After India became independent in 1947, various laws were enacted by our parliament to amend and codify laws relating to various groups within the country. The important one among are Indian Christian Marriage Act, Muslim Dissolution of Marriage Act, the Hindu Marriage Act, etc. Now coming towards the Christian marriage law. The provision of Christian personal law is regarded to marriage are to be found in the Indian Christian Marriage Act 1872. The Act applies to all Christian marriages solemnized in India, whatever be the nationality or domicile of the parties. Persons authorized to solemnize marriage. Marriages under the Indian Christian Marriage Act 1872 can be solemnized by number 1. A person who has received episcopal ordination, or by a telegram of the Church of Scotland, by the licensed minister of religion, or by the marriage registrar appointed under the Act. What are the different forms of marriage under the Christian marriage law? A reading of several provisions of the Indian Christian Marriage Act will show that the Act contemplate from the marriage which are purely religious or purely secular, as well as marriages which are of a mixed character. Marriage registrars. The state government appoints one or more Christian, either by the name or by office, to be marriage registrar for the district under the Indian Christian Marriage Act. Place of solemnization. The Act as such does not lay down the place of solemnization. However, since the marriage of certain categories are solemnized according to the rules, rites, ceremonies and customs of a particular church by the clergymen, whose marriage will be solemnized only in the church. Now coming towards the Muslim Marriage Act. In general, Muslim law is applied to every Muslim by the court. Marriage, concept and ceremonies. In Muslim law, marriage or nikah is a civil contract which has for its object and procreation of children. Marriage, according to the Mohammedan law, is not a sacrament by a civil contract. Ceremony. This essential ceremony of a Muslim marriage is a proposal from one side and its acceptance by the other side, or declaration and acceptance. The proposal and acceptance must be made at one and the same meeting. Religious ceremonies. No religious ceremonies are required for the legal validity of a Muslim marriage, though it is a usual practice to recite some verses from the Quran. The presence of a priest is not essential for the Muslim marriage. Witness necessary for solemnizing. According to the Hanif school of Muslim law, witnesses are required. They must be two males or one male or two females. A marriage not solemnized in the presence of witness is irregular, though not valid. Rules as to polygamy and polyandry. A Muslim male can have 4 wives. This is the legal position. However, there are religious mandates that the husband should treat all the wives equitably, and if that is not possible, he should not have more than one wife. A Muslim female cannot have more than one husband. Judicial separation. Muslim law does not provide for such a relief, and there being no statutory provision to that effect applicable to Muslims, it is believed that a court cannot grant a decree of judicial separation to the Muslim wife or husband. Divorce. Muslim law as administered in India provides for a extrajudicial divorce at the instance of the husband unilaterally and without requiring any ground. Extrajudicial divorce at the initiative of the husband under the constructive category. And the last is extrajudicial divorce by mutual consent as confirmed by the statute. The Dissolution of Muslim Marriage Act 1939. Next is the formula for pronouncing talaq. Talaq is generally described as an approved form or an unapproved form, but the approved form of divorce itself has 2 subsequences, Ahan and Hasan. Asan and Hasan. The unapproved form also has many varieties. A Muslim wife cannot divorce the husband by talaq. The form of divorce described in Muslim law as kula and mibarat provide for divorce by mutual consent. Conversion from automatically result in the dissolution of marriage in the case of husband. This provision continues even today. In the case of wife, by Muslim law, it ended the marriage. Custody of children on divorce. The Dissolution of Muslim Marriage Act 1939, though provides for judicial divorce at the instance of the wife, does not empower the court to pass order regarding the custody of children of the marriage. Temporary marriage. Shia law permits a male Muslim to conduct a muta marriage with a Muslim female or with a female who is a kitabiya or a fire worshipper. A Shia woman may contract a muta marriage with a Muslim male only. The period of cohabitation should be fixed, a day, a month, a year, or a term of year, and in some Dora should be specified. Now moving towards the Special Marriage Act 1954. The main objective of the Act is to provide a form of marriage which is secular in character. Its ceremonies do not depend on the religion of the parties. The entire law relating to the marriage can be gathered from the Act, and there is no need to consult the religious law for deciding questions as to the validity of marriage or the availability or matrimonial relief. Marriage under the Act is secular, statutory, uniform throughout India, uniform for all persons who avail themselves on the Act, whatever be their race, religion or caste. Formalities. A special marriage is solemnized after 21 days notice is given, so that objections, if any, to the proposed marriage may be considered by the marriage registrar. Thereafter, the marriage is solemnized in the presence of witness by the marriage registrar by requiring both the parties to sign the statutory declaration. Next is moving towards the registration. Registration of a special marriage is automatic at the time of its solemnization, since a certificate is issued on its solemnization. Next is illuminant of marriage. A special marriage may be illumined by the court on the grounds of impotency, insanity, pregnancy of wife at the time of marriage, coercion or fraud. Restriction of conjugal rights. The aggrieved party can petition for a decree for restitution for conjugal rights. Such a decree calls upon the other party to resume cohabitation. Judicial separation. A wife or husband who does not want immediate dissolution of the marriage but desires to live separately can seek judicial separation through court instead of seeking divorce. Next are the grounds for divorce. Under the Special Marriage Act, divorce can be obtained by one spouse through court on the ground of the following type of conduct or circumstances of the other spouse: adultery, treating with cruelty, discretion for at least 2 years, leprosy not contracted from the petitioner, venereal disease in the communicable form, opposite party not being heard of for 7 years, husband being guilty of rape or unnatural sex after marriage, husband failing to pay the wife maintenance ordered by the court, divorce by mutual consent. It is available under the Special Marriage Act 1954. The parties must present a joint petition to the competent court and must have lived apart from at least 1 year. On such a petition, the court does not grant divorce immediately. The court has to wait for the specified period, and the parties must then again apply to the court for the grant of divorce, and in that matter reaffirm their joint determination to end the marriage. Next is jurisdiction of courts. A petition for the matrimonial relief under the Special Marriage Act can be filed in the competent court within whose jurisdiction the marriage was solemnized on the spouse reside together. Appeals. Against the decree passed by the competent court, an appeal can be filed before the High Court. Maintenance of spouse. A court competent to grant matrimonial relief under the Act is empowered to award maintenance in favor of the wife and against the husband for such sum as the court thinks reasonable in the circumstances. Children. Under the Special Marriage Act, the court has jurisdiction to make suitable orders regarding the custody, education, and maintenance of children, and also orders as to who shall bear the expense of maintenance. Now moving towards the Hindu Marriage Act 1955. The Hindu law of marriage is contained in the Hindu Marriage Act 1955, which is an Act of Parliament of India. The Act came into force on May 18, 1955. Other acts governing Hindu way of life are the following: the Hindu Succession Act 1956, the Hindu Adoption and Maintenance Act 1956, and the Hindu Minority and Guardianship Act 1956. Marriage under the Hindu Marriage Act is both a sacrament and a contract, and it can be solemnized in accordance with the customary rites and ceremonies of either party to the marriage. Monogamy is the law, and bigamy is punishable under the penal code. The Hindu and a non-Hindu cannot marry under the Hindu Marriage Act, but they can either enter into what is popularly known as the civil marriage. This is performed by the marriage registrar appointed by the state government under the Special Marriage Act 1954. The Hindu Marriage Act applies to Jains, Buddhists, and Sikhs also. The bridegroom should have completed 21 years and the bride 18 years of age at the time of marriage. A Hindu marriage need not be registered except in those states where the state government has made it compulsory. Restitution of conjugal rights. Section 9 of the Hindu Marriage Act deals with a situation when either the husband or the wife withdraws from the company of the other without reasonable cause. As marriage is sacred, the Hindu law enjoins on the spouses to have the society or the company of each other. Section 32 of Divorce Act and Section 22 of Special Marriage Act deal with the same situation. Judicial separation. A wife or husband who does not want immediate dissolution of the marriage but desires to give to the other party some time can seek judicial separation instead of divorce. Under the Hindu Marriage Act, the grounds of judicial separation are the same as the ground of divorce. After a decrease of judicial separation, the parties are not bounded to cohabit with each other. The marriage as a legal relationship continues, subject to the above modification. Next are the grounds of divorce. Under the Hindu Marriage Act, divorce can be obtained by one spouse through court on the ground of the following types of conduct or circumstances of the other spouse. Number 1 is adultery. Number 2 is treating with cruelty. Number 3 is decreasing for at least desecrating for at least 2 hours a year. Conversion to another religion. Incurable insanity or material disorder. Number 6 is insecurable and virulent leprosy. 7th is venereal disease in a communicable form. 8th is renouncing the world and becoming a sannyasi. Number 9th is not being heard in many years. Next is the proceedings. The court is required by the Hindu Marriage Act to attempt reconciliation between the spouses, consistently with the circumstances of case. Family courts are special courts to be established under the Family Courts Act 1984. They are intended to be mailed by the specially experienced judges expected to follow a less formal approach than ordinary approach. Now in the last, there are a few questions which are based on this session. Question number 1 is explain in brief about the Muslim Marriage Act. Question number 2 is what are the provisions under the Hindu Marriage Act? That's all for this session. Thank you. Happy learning. We learning.